Okay, and welcome everybody that's attending online. Hopefully you can everybody that's here in person can join us afterwards for a cocktail at right after our panel concludes. So I'll start off by introducing the panelists and our topic for the day, which is expedited procedures under VanIAC's rules. And I'll leave lots of time at the end for questions. I've already spoken to a couple of people who've got some interesting expedited cases at the moment and who might want to start off a discussion as part of this panel. So if you have any questions, feel free to raise them at the end. So starting at the end, we have Laura Kandari. She's an experienced arbitrator and litigator in Vancouver, based here at Blake's. She's a fellow of the Chartered Institute of Arbitrators. And I have to say, Laura's involved in almost every arbitral organization that I'm aware of, including she's a former director on the VanIAC board, and she sits on VanIAC's roster of domestic and international commercial arbitrators. Sitting next to Laura is Yarden Gershoni. He's an arbitrator as well as a counsel in arbitrations, commercial litigator. As an arbitrator, his current focus is on domestic cases, and he's on VanIAC's expedited roster. Yarden is also on our board of directors for VanIAC, and he's a partner in the Kelowna-based firm Rush E.S. Hardwick LLP. Welcome, Yarden, and thanks for making the trip to Vancouver to present today. And sitting directly to my left is David Gruber, who is a partner at Bennett Jones here in Vancouver. He's the co-head of the firm's litigation and dispute resolution departments nationally, and has a lengthy list of accomplishments in commercial disputes, including as arbitrator and counsel. He's also an adjunct professor at UBC and a member of the WCAS, which is Western Canadian Commercial Arbitration Society. Finally, David, I'll mention he's also on VanIAC's roster of expedited arbitration. So all four of us have sat as arbitrator on expedited cases, and that's what we're going to be discussing today. So I wanted to start off with a bit of an overview of the expedited procedures for those of you who may not be as familiar or who haven't had any cases under those rules. They were introduced at VanIAC in 2020 when we redid our rules, and they've been very, I would say, popular. And there have been a lot of cases that have been commenced under the rules, proceeded all through to award. I mean, expedited procedures are not something that VanIAC invented. I guess when I did some research on this for another presentation, I found that the first rules were from 1992 at the Geneva Chamber of Commerce, which is now part of the Swiss arbitration rules. And these kind of expedited proceedings are an offering at many arbitral institutions such as the AAA, Stockholm Chamber of Commerce, HKIC, Singapore International Arbitration Center, and ICC, which is International Chamber of Commerce, of course. So, you know, the idea behind expedited procedures, I think, was to fit in with one of the original goals of commercial arbitration, which was to have expedited and efficient dispute resolution that would be cost effective, and that parties can, choose their arbitrator to resolve the dispute, but hopefully have it resolved within an expedited time frame as compared to going to court for a full-blown trial, for example. The VanIAC expedited procedures are defined by a monetary threshold. So disputes up to 250,000 will proceed under the expedited procedures unless the parties opt out of that. So if you choose those rules and you go to VanIAC and your case is under that amount, you'll automatically be within the expedited proceeding. There's a few features of the rules, and then I'll turn it over to the panelists to talk a little bit more about engaging the rules and how you get into the proceedings. I'll mention, and I think this has been a very attractive feature of the rules, that there's a flat rate fee for the arbitrator. So for cases up to $150,000, the arbitrators paid a flat rate fee of $5,000. And for cases from 150 up to 250,000, that amount's doubled. So it's a $10,000 flat fee for the arbitrator, which is a real deal. Because it's a lot of work to act as arbitrator in these cases. Typically, I mean, some of them may be very straightforward and may even settle before you get to a determination. So the default with the expedited procedures I'll mention as well is not to have an oral hearing. You're not entitled to an oral hearing. It's up to the arbitrator's discretion, and the parties can apply, and the arbitrator will determine whether or not a hearing is necessary. So that's a big difference from a court proceeding, obviously. And if an oral hearing is determined to be warranted in a particular case, the default will be to a one-day hearing. And only in exceptional cases would you have a multi-day proceeding. And the reason behind all of that is that the expectation is everything will be exchanged in advance. The evidence will go in through written proceedings, almost. I think I've heard David refer to it as a kind of petition proceeding. So all of the witness evidence and statements and key documents all go in beforehand, and the hearing itself is typically cross-examination of the witnesses on their witness statements or expert reports of experts. So there's a set fee for the arbitrator's time. If there is a hearing, that's $450 an hour. And the timeframes are expedited, as you would surmise from the title of the proceeding. So all of the written materials are to be exchanged within 90 days of the appointment of the tribunal. Typically, it's the tribunal is the sole arbitrator. And the time frame in which the arbitrator is to draft the award is also very quick. It's 30 days from the submission of the final written submissions, where there's no oral hearing, or if there's an oral hearing, it's 45 days. Now, not necessarily every case is going to have the award issued within that time frame, but that's what's in rules. So these expedited proceedings offer the potential of a more efficient process where the monetary value of the claim doesn't necessarily warrant a full-blown process like in regular arbitration. And I would argue that given the popularity of this offering at VanIAC, these rules do kind of fill a gap that users had a need for. So this panel will explore some of the practical issues that arise with these expedited procedures, as I mentioned. So I want to start it off by turning it over to you, David, to talk a bit more in a bit more length about how to access these procedures and when they would be triggered and when they would not.
So as always with arbitration, this is a question of party autonomy. And so it's up to the parties ultimately to decide this. But there's a few different paths that are established by the rules. The first being that if you have named the VanIAC rules in your arbitration agreement, then by default, if it's a domestic case and the monetary amount is less than $250,000, it will go to an expedited arbitration. You commence your arbitration by sending notice to arbitrate to the center, which will be accepted as an EP case and administered as an EP case. Or if it's an international case and the monetary threshold is beneath $500,000, the same thing will apply. As Sarah mentioned, it's up to the parties to agree not to do it that way, of course, but that will be the default if you've specified the VanIAC rules in your agreement. I should caution and say that it's not the case that if no monetary amount is specified in the claim that it goes to expedited procedures. If it's no monetary amount specified, it will go under the regular procedures unless the parties have agreed on this. So it's if there is a monetary amount specified, it goes to arbitrate, but it's less than the threshold under either the domestic or the international. As Sarah mentioned, There is the possibility the parties could agree otherwise after proceedings commenced or before the proceedings commenced. It's also possible under the rules for the arbitrator after appointment to determine that it can't be dealt with under the expedited rules. But the default will be that it's dealt with under the expedited rules in those situations. If there is a specification of the VanIAC rules in the arbitration agreement and the amount claimed is more than the monetary thresholds, the parties are still nevertheless able under the rules to opt into the expedited procedures. They would have to both parties agree, or all parties in multi-party arbitration agree that the expedited procedures would apply. And of course, there's also the possibility of a submission to arbitration using the expedited procedures if the arbitration agreement doesn't specify the VanIAC rules, or if there is no arbitration agreement to begin with. And there have been a number of cases that VanIAC has accepted where the VanIAC rules are not specified in the arbitration agreement, but the matter has nevertheless been administered by VanIAC as an expedited proceeding. We would surmise from that that the parties have agreed to submit the claim to VanIAC administration as an expedited proceeding because of the attractive features of that, given the size of the case. Particularly, as Sarah mentions, the fixed fee for the arbitrator may be very attractive. We haven't directly seen this, but it strikes me that the whole litigation community might consider submission agreement for smaller claims under the expedited procedures where there is an appetite of the parties to do so, particularly given the fact that the attempts by the court to streamline smaller cases, I think largely it's been agreed, haven't worked. The simplified trial proceedings under the rules of civil procedure are hardly ever used except in very narrow types of cases. So it's something that as counsel or as somebody who's involved in the community, people might consider suggesting to people who have smaller monetary claims that just simply can't be dealt with through litigation because of the complexity and delay inherent in litigation.
Yeah, well, he makes, thanks, David, and makes some good points. And I'm gonna turn it over to Laura in a minute, see if she has anything else to add. I mean, one thing that I thought of while you were speaking is, yes, you did mention that this is also available in international cases. So where one of the parties is not based in Canada, or I think it's some other ways you can get into the international rules, but and so that's a great thing to keep in mind. A lot of the international disputes are typically going to be above the monetary threshold, but that doesn't mean all of them would necessarily be. And parties can opt in, and you can end up in also scenarios where, let's say, you don't forget the counterclaim. So sometimes what will happen is somebody starts the claim, it's within the monetary jurisdiction, along comes the counterclaim. It's like 750,000. So what are you going to do then? And the rules do address that particular scenario where the arbitrator can negotiate a rate or set out terms in terms of how to deal with that, and can be creative in terms of making it work. It's also interesting to consider opting into these rules where, as you mentioned, there's no monetary amount, or it may be a claim for a declaration or some kind of declaratory relief. It may not be every case that's suitable. And so maybe, I don't know if you have anything to add, Laura, with respect to this first question.
Yeah, just a couple kind of more practical things. The first one is that, yes, of course, party autonomy and the parties can opt in, but I think as an arbitrator also, you may look at a claim and you may have been appointed not under the expedited procedures. You may suggest to the parties, hey, I think you take a look at this and consider if this is applicable. You may or may not want to accept a flat fee arrangement, but I think that that's our obligation to just think of how best to make the process efficient. And I've definitely done that before. In terms of the actual mechanics with one of these, if you haven't done it before, One of the nice things about an administered arbitration is when you file the notice with VanIAC will make that initial assessment and determine whether you fall under these procedures or not, which is important because with the smaller claims, we often have unrepresented parties or counsel that have never been involved in an arbitration before. And then the other thing I wanted to add, because I know there are a number of lawyers who I think are probably at firms where they get consulted on arbitration provisions. This is something you need to think about when you're talking to your client or your drafting solicitor about the arbitration agreement, because they may not be aware that under a certain threshold, their claim could fall into expedited procedures. For some people, that's a pro, for some it is not, particularly with there being limited appeal rights for domestic arbitrations where there wouldn't otherwise be. So I think that's sort of part of your job as well, is to be aware of these and advising on those. And conversely, I've also seen solicitors drafting kind of their own little expedited procedure in a contract. So we also all have a responsibility to let people know that these are options available to them. But nothing else on sort of how you get into this process.
One thing I've seen come up is parties have approached me out as an ad hoc arbitration, which means they would not have the institution involved. And I think with the expedited rules, it is the flat fee is great, because the VanIAC, first of all, if you haven't agreed on an arbitrator, VanIAC will assist with appointing the arbitrator from its roster of expedited arbitrators that are all vetted in terms of their experience and their knowledge of arbitration and previous arbitration experience. But also, you know, when you're approached as an expedited arbitrator outside of if it's not administered, I'd say you have a lot more flexibility in terms of negotiating a rate. I wouldn't necessarily be inclined to take on the flat fee rate if it wasn't required. But it's going to depend on the arbitrator and their caseload and a number of other factors, obviously. But drafting that arbitration clause, and specifically if you wanted to have these procedures in it, you need to include that in the clause. Because once you're in a dispute, it's very difficult to agree with the other side, obviously. Okay, so the next question I had here was just, you know, these expedited rules, as I mentioned in my intro, have been very popular. And I wanted to ask you, starting with Laura and then Jürgen, from your perspective as arbitrator and or as counsel, what are some of the greatest sort of strengths and weaknesses of the procedures, or the good, the bad, and the ugly, if you will? And so I know you just spoke, Laura, but I'll turn it back to you.
Thanks, Sarah. So from the party perspective, I think the two big things people are thinking about are the cost and procedural fairness. On the cost side, I think these rules are definitely less expensive. It's a very short time frame, and there are a lot of cost savings compared with traditional arbitration. Arbitrator fees, certainly. And the streamlined procedures also result in less legal spend. If you've got a small window, you're not going to have, you know, a 6-month Redford process, for example. It's just not possible. I think one thing that can sometimes bite parties a little bit at the end is that costs are still typically awarded on an indemnity basis. So even though your process was very efficient, there could be a significant legal spend in that period, and that legal spend can sometimes equal or exceed the amount of the claim. So good for the successful party, but can be a bit painful for the party that is not successful. And then in terms of procedural fairness, I think there's always a concern about that being compromised where the process is more streamlined. I have found that the lack of voce evidence has not been an issue. There's, in modern cases, there's usually such a volume of corroborating documentary evidence that it becomes fairly apparent what, you know, the correct narrative is. And if you look at like the science behind truth telling, we're actually very bad at assessing verbal evidence. And I think all of the expedited procedures arbitrations I've done as arbitrator, no one has ever requested the oral hearing. So I think that shows that the parties were satisfied that they were able to put their cases in without doing that 1-day hearing. Which, yes, there's an additional expense, but I'm not sure it would be that exponential if they were concerned about procedural fairness. As an arbitrator, I think these can be kind of challenging. You're undoubtedly going to be putting in a lot more time than your flat fee. But I think you can either consider it to be good experience, and I've been lucky to always have good counsel on mine that have made it a really rewarding, enjoyable experience. Or you can consider it maybe a service to provide access to justice the same way that people do in other ways. The other thing that can be a challenge with these is you get a lot of self-represented parties. I haven't had any of those myself, but that can make things quite uncomfortable. That's you don't, you have to get them to pay you, and you have to get them to provide materials, and the process can become a little unwieldy. I don't know if you've had that experience.
I have,
Yeah.
yeah, and it is on.
Yeah, because you end up in the scenarios where it's the procedural fairness, I feel like, comes in even to a greater degree when you have the one side that's represented and the other that isn't. Did you want to add anything to what Laura was saying?
Yeah, so I mean, I agree with everything that Laura said. I also, I mean, I've done more than a handful of these expedited cases, and I've also never had counsel request an oral hearing. And I think if counsel did request it, our obligations under the rules are to order one only if it's necessary. So unless both counsel want it, in which case I think you do it. I'm not sure that I would have ordered it if in any of the cases I've had, because I agree, I haven't found it difficult to make a decision based on a lack of cross-examination on the affidavits, on witness statements. I mean, I think the greatest strength obviously is the time frame. It's the costs and the time frame. I don't know the statistics exactly, but I think it really is feasible, unless there are exceptional circumstances, to get one of these cases done in 6 months from start to finish, and it could be quite a bit shorter.
Yeah, I think that's right. I mean, I'm looking at Ina. I think she
Yeah,
kind of nodded.
Yeah. So, and they're not large disputes, but they're not small claims disputes either. You have up to 250,000 exclusive of interest and costs for both the claim and the counterclaims. So you can have a $250,000 debt plus interest, and then on the counterclaim you can have the same thing. So actually the amount in dispute could be $500,000 range or more, and you still get a process that doesn't take years, which is quite excellent. I think $250,000. I think for domestic cases, it's actually $500 for international. Is a realistic threshold. I think a lot of cases fall in there, right? I mean, and it's difficult, from my perspective as counsel, to know what to do sometimes with those cases, right? Because they're big enough to fight about, but they're not big enough to take to trial. And this really does provide an opening to get those done in a way that actually makes sense.
It's interesting, the threshold you mentioned, you think that that's the right amount for our jurisdiction. And I had looked at the thresholds for some of the other institutions to show the kind of magnitude of the quantums in certain jurisdictions. So at HK, it's $3 million is the threshold for expedited procedures at HKIAC. So totally different kind of ballpark. US 4 million for CF, which is the Singapore, and then but ICDR, which is the international arm of the AAA, is more comparable to the VanIAC expedited procedures at US 250,000.
Yeah, I think it makes sense. I mean, I don't think as a board we've had any reason to critically look at the numbers really.
Well, and I
We'll
guess
talk
if
about in the
parties
future,
do want to opt in, even though the dispute's higher, they can do so and negotiate a different rate with the arbitrator, right, or different terms, so.
Yeah, another strength, I mean, I could probably go on for a while, I won't, but, I do think it's a good opportunity for, you know, sort of younger, up and coming arbitrators to get, you know, to apply to the expedited panel at VanIAC. And then, you know, it's a way to get experience. I mean, you don't get paid a lot of money for it, but you do get good experience because as we all know, just because the case is relatively small in dollar figures, it doesn't mean it's easy to resolve, right? It's will be complicated. So the flip side of that is that you don't get paid very much as an arbitrator, but I think you get value, and I think the whole system gets value from it. And then just one weakness, which I guess I'll reiterate what Laura said, is that very complicated cases can still fall below the monetary threshold. And then everyone's conception of timeliness can get challenged, right? Because you're in an expedited process and everyone expects it to happen really quickly. But there are certain instances where justice requires more process. You're still within the expedited procedure, but you know, you obviously need to balance procedural fairness against expeditiousness.
And I mean, the arbitrator does retain the discretion to determine the process, so where unexpected things arise, or the case takes a turn, you know, it's not that you're rigidly bound by, well, no, you only get one exchange of memorials, or, you know, you probably have your procedural timetable set. But I have found in cases where, you know, something has come up that was unexpected or whatnot, that usually we're able to find a process that arrives at that correct balance. But yes, I would say it's definitely possible to do a case, you know, in 3 months or 6 months, but it's going to depend on a lot of things, including everybody's schedules and these eventualities that arise. And it's interesting because we're all talking about 250,000 as being a very, you know, moderate or lower kind of threshold, and that none of the parties are requesting an oral hearing. But I've discussed these rules with some of my kind of litigation colleagues in Vancouver who've been kind of shocked by that, saying they would never give up the opportunity for an oral hearing. And that even in small claims court where the case is, you know, 25 or 35 grand, rusty on my small claims experience now. You know, they get their trial and they're your day in court or whatnot. So, but obviously you're dealing with a different type of dispute typically, like Laura said, where you're contract driven, document driven. I have had one case where the parties did not request a hearing, but they said if it would be of assistance to the arbitrator, you know, let us know. And I said, I did ask for a hearing because the witness state, the witness evidence was so contradictory, and the documents were not necessarily always helpful. And I felt that it would be useful to hear directly from the witnesses, cross-examination. So, yeah.
I would say, I haven't had a hearing, and I've probably done a half a dozen of these. But I have requested further submissions or evidence by email from time to time, where I, upon reading the parties' submissions and evidence, felt that there was some issue that needed to be grappled with in order for there to be an enforceable award, or where there was a gap in the evidence where I could issue the kind of award I was being asked to without more evidence. But I found that I could do that by email and fill the gaps that.
You know, a broader question that I was thinking of is, where do these expedited procedures fit in the overall dispute resolution toolkit? So we just talked about small claims, cases, and we've talked about trial and petition proceedings. And so David, I don't know if you want to comment on that.
Yeah, so I mean, I think if you think about who the potential customer is for this, you are thinking about probably small businesses and individuals to whom this is a significant enough sum that they're not gonna be able to walk away from it if they get a recalcitrant respondent who's unwilling to pay. That is a tremendous advantage to individuals and small businesses for whom this is a material amount of money, to be able to say, no, look, you're either going to deal with my invoice or there's going to be a process. Whereas if you don't have this in your toolkit, you're probably not economically able to pursue claims of that magnitude. It's potentially attractive to larger businesses that have a lot of smaller transactions, who probably have the ability to write off amounts of this size, but could improve their bottom line if they didn't write off amounts of this size. Depends, I think, on the materiality of it. It's a particularly useful tool, I think, where you are dealing with the non-responsive counterparty. In fact, in a couple of the cases that I've sat on, the respondent either didn't participate at all or participated very remotely from the proceeding. And those are the ones that you can deal with fairly quickly, although you cannot deal with them on a summary basis. There isn't summary judgment per se or default judgment per se. You still have to receive the evidence, right, a reason for it. But obviously you're not dealing with any contested facts or really much of an argument to put the law, although you may still have to issue some questions to the parties in order to fill out some gaps, but nevertheless. So I think that's the sweet spot is where you have the party that's just non-responsive to the demand. But as well, I think it is a tool which you could look at, and your litigation colleagues are shocked by the fact that you don't get your day.
It wasn't somebody at VLG, but.
But in reality, you can't do a Supreme Court trial for a claim for less than $250,000. Even the most economical junior counsel just simply can't do it.
And it'll take you 2 years to get to your oral hearing.
At least 2 years. There's just too much process. And think about what the day in court costs. So I think that there is a market there for people who want to submit to this process claims for which there's no arbitration agreement at all, but who it's mutually important to have a decision that's based on law. And how else could you get?
Do you agree, Yarden?
I do. Yeah, I mean, I, as I mentioned before, I think that range of amounts in dispute is it really is, this really does fill a gap. The one thing that I'll say and I'll stress, I guess, is that in order to engage this particular tool in the toolkit, as Sarah put it, it's much better for the claimant in particular to have an arbitration clause naming VanIAC as the institution. It's much more difficult, obviously, to get it into that process or a process like that after disputes arisen in the absence of an arbitration clause or in the absence of an arbitration clause naming VanIAC as the institution, or at least its rules. So, you know, I suppose it's pitched to the audience to some extent to the extent that you have solicitor colleagues providing comments to the arbitration clause or asking them to add an arbitration clause naming VanIAC as the administering institution is the way that you actually get this benefit for the parties. You might still get it through a submission agreement later, or the parties might agree, yes, we actually want this to be expedited later. But the chances of that happening are significantly lower, obviously, than if a party has a right to this expedited process through an arbitration clause. And there obviously is a model clause on the website. Encourage everyone to check it out.
Yeah.
And advertise it to your solicitor friend.
Yeah, I think one other thing I would add is that apart from the delays in getting court time, I think that there's a lot more opportunity to create procedural delay in the court system versus a closely managed arbitration proceeding. And so particularly where you might have a disparity in sort of resources of parties, where one party could take advantage of that, I think that these procedures can be really good at kind of leveling that out. You know, you could have a well-resourced party that could stretch a petition proceeding out for 5 years. I've had that
Right.
happen.
Yeah.
So it's something to think about from that perspective as well.
And if, yeah, so if you're council, or if you're considering eventually trying to get on the roster to act as an arbitrator in these types of cases, these are all important things to think about. I mean, I've had, I think there are some cases that are coming to us through the expedited proceedings that probably are not the best fit for expedited cases. And parties are kind of trying to shoehorn in because the flat arbitrator fee and the filing fees are reduced, administrative fees are more reduced. And but you know, and if the parties are upfront about that from the get-go, and the arbitrator is open to that and may even negotiate something for working around that, that's fine. But it's important to be aware of the clients, to be aware that, you know, for example, if you go strictly by the rules, what's permitted under the rules, you won't have you won't have a bifurcated proceeding, for example. You won't have a situation where you provide your written argument and your witness statements, and then you automatically have an opportunity to do a further round of submissions unless that's been written into your procedural schedule. And I've had situations where the parties have shown up to the first procedural conference and said, well, we want to bifurcate, and both parties agree. And so this is what we want to do. And this happens a fair amount with, in my experience, with proposing kind of your own kind of approach that's not in the rules. And in that particular case, I found, I wanted to allow the parties to design a dispute resolution process that if both parties agreed to it, worked for them. So in the end, I did the first, so liability was determined under the expedited procedures with the flat rate fee. And then there was a separate process, because I said, well, either you could do it as like 2 separate arbitrations with 2 flat rate fees, or we could switch, if you continue after the first phase, to an hourly rate. But I'm not going to do 2 separate entire proceedings all under 1 flat rate fee, because that's not what the rules provide, and it's a huge amount of work and whatnot. But so there's definitely ways to be creative with the rules, I think, and with arbitrators, with your terms of appointment and what you're willing to kind of take on. Murray and I were chatting before this about making sure you ask a lot of questions at the first procedural conference, and that's kind of where I'm going with the next question is, in terms of running these cases expediently as an arbitrator, as counsel, which I think everyone here is, do you have any tips for sort of handling that initial phase of the case from when you're appointed to that first procedural order, and what works well for these kind of cases? Your view.
Yeah, I think one of the things I was going to say, you've already kind of said, which is being open-minded about the process. And, you know, you don't necessarily want to just go in with a fully pre-baked procedural order number 1 and impose it on the parties. You will probably know process very well, but they know their dispute. And I've been surprised sometimes at the ideas they've come up with that still will fit within the expedited procedures. So I think that's a good kind of mindset to have. Because you may have parties that are less familiar with this, I will typically send some things in advance. So I'll obviously send the draft appointment agreement, an agenda that may be quite detailed in terms of this is what specifically we're going to talk about under this heading. And I might also send things like, you know, links to sample forms that VanIAC has, or a sample Redfern schedule, so that everyone has a little bit more background going into the conference. And then at the conference, often I've had, you know, either parties that this may be their first arbitration, or counsel that it's their first arbitration, or expedited arbitration rather. So it's helpful to just kind of give a little overview of that process. The other kind of more practical tip I would have, and this is sort of procedural order number one and procedural conference number one related, is to make sure that you're going to end up with a final award at the end of this process. So that means you need to talk about how cost submissions are going to be dealt with. You know, you can maybe get to the point of you're working on your award and issue some more questions, as David has answered, but if you can put as much of that into the procedural order as possible, then everyone knows how it's going to go and you're not gonna end up with, for example, second costs process, which in itself can sometimes be quite involved.
Anything to add?
Yeah, so I'll say, have been as privileged as Laura in terms of having counsel who are familiar with arbitration. So my practice has evolved a bit on these first procedural hearings. I mean, they happen quite quickly after the appointment. They're to happen within 10 days. But I have found that the parties will often not have read the rules unless they've been told to read the rules. So one of the practices that I've
Drop that down.
come to when sending out the invitation to the first procedural conference is a link to the rules and asking the parties to spend some time reviewing the rules beforehand. I also have a fairly detailed agenda that I've developed for the first procedural conference. And where I have self-represented parties, I send a template procedural order number one, not when it's both parties represented by counsel. But I think it evens the playing field a little bit if you have self-represented parties to have a template PO1 for them to look at before you start asking. I agree with Laura wholeheartedly about costs. I insist that the costs be dealt with before the award. Because that's the contemplation of the rules. If this proceeding is going to be done expeditiously, I mean, if the parties came to me and said, we absolutely don't want to do them that way, I might have to, as Sarah says, negotiate something else. But I think the intent of the rules is they're dealt with. And I've also come to talk about interest with people at procedural conference number one. How am I going to calculate it? What is the date of calculation? Are there issues in the case that's going to change the way it's calculated? Because I found in a couple of my earlier ones that I had to do my own algebra in order to render a final award. And I'm pretty good at algebra because I have an engineering-based degree, but I'd rather not be doing that. So something else I've come to talk about.
Anything you want to add, Yarden?
Yeah, maybe I think differently than both Laura and David, and maybe I need to change my methods a bit, but my practice has always been, I have a procedural order that is that I like, and I like using it if possible. And I do send out the template beforehand, and ask counsel or the party, if it's unrepresented, to comment on it and be prepared to comment on it at the hearing. Seems to go fine for me. As far as I can tell, usually, or as far as I can remember, usually people don't have material changes to it. And that might be part of the problem, I suppose. But, it sets up a process that I'm comfortable with and that I know, and it's worked. So I guess it's just different, there's different approaches, right? Slightly different approaches.
Yeah, I think the key thing is allowing the parties to comment on it, weigh in, and because it is a kind of an agreement, or depending on how you set it up, but usually it's an agreement, something that the parties have agreed on. And I do a similar thing, so I'll often say, if the parties have agreed on a proposed procedure, circulate that or let me know. Otherwise, I can circulate a template, and often they'll ask for it or say, we would greatly appreciate that or something. And so the issue with costs, I'll just, in case you haven't been through one of these expedited procedures, it's quite interesting because it kind of sneaks up on you, right? If you haven't dealt with it at the first procedural conference, it's not written into your procedural schedule. Everything will end after that round of submissions, unless either party requests a hearing and a hearing is granted. And so then it turns over to the arbitrator to draft the award. So you have to put in figure out what you're going to do with costs at the get-go, I agree. The parties that are not used of providing submissions on costs prior to the outcome of the case will find that, in my experience, kind of uncomfortable or unusual, and will say, you know, it's okay, just tell us the outcome of the case. We'll go away and try to resolve costs like you would in a litigation matter. And then we'll come back to you if we need you to make a determination on costs. But actually, the case is done. If that's how your case is laid out in the procedural order and under the rules, the case is done and the arbitrator technically could be no longer have jurisdiction unless you built that all into it, or I don't know how you structure it. But and of course, the party that wins is going to say that you know, all of their legal fees and time was very reasonable if they win. But if they lose, they're going to say the other side was extremely unreasonable on how they managed the case and all the time they spent on it. So it is very helpful as a arbitrator to have the submissions from the parties prior to the outcome of the case. You know, I have had workarounds where they'll say, well, we don't want you to determine that issue. Can we come back to you? And I've been offered some flexibility around that. Usually I think I don't have that many cases under my belt, but I've never had the parties agree on their costs. So they almost, you know, I think it's most efficient to include it in, and then you would go back to the parties to get any updates on legal fees and time spent prior to issuing your final award.
I think you're not gonna get agreement likely on costs because it's indemnity costs. Counsel who are used to litigation are thinking that it's gonna be tariff costs, and that's why they'll agree, which it's not how.
This is surprising to me because I've never had a case where we dealt with costs at the time of the award on the merits. Why not just do a partial final award on the merits and then the final award on costs after, so the parties?
Yeah, you can do that for sure, like a partial award, and then you could get the submissions from the parties,
Yeah.
is that what you mean? And then
The
do
cost schedules, you don't even, yeah.
Well, I guess some arbitrators and parties may prefer to get the submissions before they issue the outcome of the award, because then the parties have to be somewhat more objective. In the sense that once you win or once you lose, you're going to argue that, you know, you're biased in how you view what's reasonable, or, because you still have to say reasonable. Arguably in BC, the law is that you're awarded your full indemnity reasonable costs. And so what you're arguing over at that stage, you see what I mean? Like, if you don't know the outcome of the case.
Yeah, I do. It's just
Yeah.
every case I've had, we make the argument of the winning party argues why they should get their costs and the losing party says why they should get a
Well,
portion
not
or less of it.
necessarily like because I think it's pretty clear that the winning party typically will be awarded their.
Not
their
necessarily,
indemnity.
the contracts often, like lots of contracts will specify the arbitrator's costs are split between the parties and it's just legal fees that are up for grabs. Or it'll say it depends on the success, or it'll say the parties are just eating their own costs, like I think.
But
it
in
depends
terms
on-
of arguing over like what was a reasonable amount of time to spend, if you have both of the parties' submissions on costs and you can see that they're fairly equal, for example, the amount of time that they spent, then you don't have, I think it's helpful as an arbitrator.
Yeah.
I would say, Alex, one thing to keep in mind is the intent of these rules is you get to a final award within, you know, less than 6 months. And as an arbitrator, you don't want to be writing a partial final award and then a supplementary award.
that's fair for
costs, because you're not getting paid for it, which is why I really push the parties to do it before the award. I mean, I think in a non-expedited arbitration, there are arguments pro and con for doing it before the award, but I think the intent of the rules is such that it's much better satisfied in the EP context by doing it before.
There's one caution I think that we should think about, and that is that while the parties agreeing to expedited rules give up the right of an appeal on a question of law, they don't give up the right to challenge an award on the basis of a denial of due process. When you make an order that each side will deliver their submissions on what they say are their reasonable legal fees, I think there's an obligation to make sure that there's a because the cost can often exceed the amount in issue. And that there should be an opportunity to make full answer and defense to the other side's submission on costs. So I think that in the procedural order, you have to build in that you give us your position on costs in advance and you give an opportunity for the other side to respond again before the final award, just so that you don't create that appearance that you've made a decision without equal treatment to the parties.
The other thing you have to think about is sometimes there may be a settlement offer that you don't want the arbitrator to see before the arbitrator makes the merits decision. So I have had, not in an expedited procedure, but in another arbitration where the cost submissions were essentially sealed. And the arbitrator agreed only to look at them once the determination on the merits had been made. So it would still all be in one award. But the arbitrator just essentially undertakes that they're not gonna look at those submissions until they've made the decision on the merits. But that is something to think about because you don't necessarily want the arbitrator seeing a settlement offer while they're thinking about the merits of the case.
That's a good point. Oh, yeah, cost raises a lot of interesting issues, actually. Okay, so for our final, unless there's any other questions around that, we have a few more minutes and I said I would leave time for questions. Maybe I'll just ask if anyone has anything and then I have one more question for the panel if we don't have time. Go ahead. So I'll ask you and then Alex.
You mentioned earlier about settlement. Where does a settlement fit into this flat fee? In other words, parties have given you a flat fee. They've deposited halfway through in the case, they settle it. Where did that, can you apply the exact amount? You have to go back to your hourly rate. How does that square with this?
Right. You know, I think that's an area that is not expressly addressed in the rules, would you say?
So yeah, I mean, different EP arbitrators have different practices. Some will, I think, take the position that they've earned the fee, even if they don't. My practice is to request half the deposit in advance of the first procedural conference and half the deposit before I have to start reading the memorials and evidence. And if it settles before I start reading the memorials and evidence, I'll charge on an hourly basis. And if it's after that, I'll charge the full fee. Other people might charge the full fee.
So you would set that out in your terms of appointment? Any other thoughts on that?
Yeah, I've done something similar where there's sort of a specific procedural point after which, or before which I won't charge, you know, I might charge something nominal. And then after that, the full fee, but the rules do not, the answer is the rules don't specify what happens.
Yeah, it states that, I think it states that you pay the fixed fee. The arbitrator is the one that determines when that is requested, I guess, in conjunction with the institute and with the center. And so if it's your practice as an arbitrator to request the payment at the beginning of the arbitration, you know, before the first procedural meeting, I mean, I usually do it after, but it depends on the individual's practice. I think you could, it's something to clarify. Would be a good thing to clarify at the stage of the terms of appointment, but it's often, I would say that's something that's often not addressed, actually, in my experience.
Yeah, my practice is actually the same. I think I might have got it from you, David, I'm not sure, but it is exactly the same, and but it's I mean, about the rules, my interpretation of the rules is that the fee is earned as soon as the arbitrator is appointed. Although I, you know, personally don't take that approach. I asked for $2,500 before the procedural hearing, then the same $2,500 before I need to read any materials, any substantive materials, and if it settles at any time before I read an award, it's basically hourly. So
And don't you find that that typically is the full amount
Yeah,
that your hourly
probably,
rate? Yeah.
probably,
Depends.
yeah.
Alex, were you going to jump in?
It was, but this is a good point that I think is something the rules committee will consider.
Right.
For costs, if there's ambiguity on it. My question was whether you've ever in an expedited case thought about, as the arbitrator, telling the parties there's a page cap on how long their memorials can be. I know for a witness statement that would be hard to do, but at the very least on a memorial or a written submission.
I haven't. I mean, I have a mixed mind about the question in the sense that it is more work to read more, but on the other hand, the more assistance you get, the less work it is to write the award, so balancing act.
Yeah, I've had it, but I don't think I imposed it. I think it was sort of in discussion with the parties. It's not a bad idea. For at least the memorial, maybe the witness.
Yeah, I think for a witness statement, it's probably too hard from a procedural fairness standpoint if you don't have a hearing, but at least for a written submission, maybe.
I haven't asked for a page limit in an expedited procedure. It's a little, I think it's a little bit more time to read more, but I just think, it's not so much more time that personally that it would make a material difference, I think, for me. I have in a non-expedited procedure discussed with the parties the concept of a page limit, and they have put one on me. And I was rather happy about that.
I have used them in consultation with the parties on a second round of submissions where they had some document requests that led to further issues coming up and they wanted to make further submissions. And I said, okay, but they're going to be limited to, and you can always apply to the arbitrator to modify that if there's an issue. But I do think in certain circumstances where there's maybe a lack of focus in the case, it can help focus, I think, on the strongest arguments. So, but time, not every case I think is suitable. And also you can end up in circumstances where you get like quite the small font and the margins are very thin and, Any final question before we conclude?
I'm just curious, I think more than one of you has said there's been the odd case where costs have exceeded the amount in issue, and I'm just wondering why you think that might be. I mean, if this is supposed to be quick and efficient, that doesn't strike me as a hallmark of efficient process. So maybe it's like a $50,000 case where the costs are more than 50, but I'm also thinking it's like a $250,000 case. Is that what you're seeing, or what? And why do you think that might be? Are the council doing it wrong? Like, are they over?
Good question.
The one I had, I think it was probably not a 250, it was probably a 150 case. But I don't think the council did anything wrong. It was a really complex case. And it was within the timelines. And I think, if you think you're right, then kind of justice is served because there's this little additional penalty to the other side, right? So there's sort of a behavioral deterrent aspect to arbitration, which is reinforced by that. And I don't think it's that common that you would exceed the amount in dispute, but it does happen.
I had one which was a smaller value thing, around more towards the 50,000 one, and it just you have to do the work to get, because we don't have default judgment, we don't have summary judgments, you still have to prove your case. They weren't willing to walk away from the 50, so I think that's. I felt it was proportional. I think, in the reasonableness assessment of costs, the size of the case is a factor.
So I was going to make a comment on that, David, and that I think that the expedited procedures do provide a very useful tool to relatively small claims cases where you, as you say, you can't go to court. I think that the center might consider filling other gaps and, for example, make a provision where the parties could elect for final offer arbitration, no written reasons, flat fee, no legal fees. There could also be, pursuant to what you just said, a provision in the expedited rules that say the arbitrator in assessing the reasonableness of costs should take into account the amount in issue. Because you could have a $500,000 legal fee on a $250,000 claim.
It's a really interesting question because we're assuming that the amount of work you put in is going to be determinative by the quantum of the case, but it could be an important this could be an ongoing relationship where there's multiple agreements that are similar or other factors going into it. So it's not always going to be the case that you can run it very lean legal wise. And it's a really interesting point because when we talk about efficiencies, we are talking about the arbitrator's fee is, I would say, lower than what you're gonna get if you have to go pay an hourly rate. Most experienced arbitrators rates are higher than the flat fee or the $450, I think it's in there. But the time council have to spend on a shorter time frame could be like squished. Basically, it's the same amount of work, but it's just spent over fewer months. So it's not necessarily going to be lower legal fees. But if you have a tight process that doesn't get drawn out with delays and further rounds of submissions and evidence, presumably that will be lower legal fees. It depends, on the quantum of the number of documents you have to go through as counsel. So you do see a real range, and presumably there's a limit on what would be reasonable, but I don't think there's a lot of guidance in the case law on this point.
Yeah, I mean, one of the
Yeah.
benefits of having everything in the final award and having both council submit their costs to you is often there's not a massive differential in the two costs that are submitted. And if there was, then that might be a place where you say, yes, you were successful, but your fees were unreasonable. So I'm reducing them by X amount. So that also provides a bit of a check on the legal spend.
And sometimes there's not full success.
Yeah.
Sometimes you're gonna knock them down because the claimant's only been successful in some issues, but not others.
Great questions.